Good morning, everyone, and welcome to Veryl's 2021 annual update and the second portion of this year's online annual update. As many of you know, while normally Veryl loves to condense a full day of information at the beginning of the year in January of each year, that didn't happen this year as a result of the pandemic and us wanting to make sure that we kept everyone safe and healthy. And instead, we've chosen to offer a year-long seminar-style presentation of all the topics that we would have been covering during the course of the annual update. So those each occur on the third Thursday of every month. So mark your calendar for this 9:30 time slot on the third Thursday of every month. And part 3 of Veryl's annual employment law update will be occurring on March 18th, 2021, entitled The Effect of COVID-19 on Employee Benefit Plans, Making Sense of the Abundance of New Legislation and Guidance. And in that presentation, you're going to join Karen Hartford, Bill Jewett, and Chris Lockman as they discuss the various relief provided by legislation, regulatory action, and other agency guidance intended to assist employers, plan participants, and ERISA fiduciaries during the ongoing COVID-19 pandemic. Today, however, we are going to talk about the gig economy, independent contractors or employees, and why the designation matters. I know many of our attendees personally, but for those of you who I am not familiar with, my name is Tawny Alvarez, and I am a partner in Veryl's Labor and Employment Practice Group. And with me today, co-presenting, is the newest member of Veryl's Labor and Employment Practice Group, Emily Coombs, and she'll give a little wave. So we're going to jump back and forth with the information. As I noted in the chat, you're going to be able to access the slides for your own use during the course of the presentation. And with that, let's get started. So we're going to go to the next slide. So agenda. I think it's important that we talk about what you're going to take away from today's presentation so that we start on the same page so that when you walk away, you know this is what you should be walking away with. 1, why does the question of employee or independent contractor matter? We're going to have a discussion about the difference between the two and the general risks associated with misclassification. We're also going to talk about the differences in standards. So we're going to talk about the full standard and the fact that the administration change affects what that looks like. For those of you who follow kind of the changes between the administration, between what Trump's administration and the Department of Labor had been requiring and what we foresee the Biden administration providing, there's some significant differences in the independent contractor standard and how that affects the gig economy and classification more generally. We're also going to go into detail about the Maine, Massachusetts, and Connecticut Standard. Now recall that those standards are going to be most important based off of where the individual is working from. So it doesn't matter if your company or your organization is incorporated in Delaware. You're not going to be using Delaware law for that. You're going to be focusing on the location of the employee or independent contractor, more generally worker, where the worker is providing services to determine what standards are going to play a role. In discussing those standards, we're also going to talk about the risks. So what liability could you be looking at if you had a misclassification claim? We're also going to jump and kind of talk a little bit about independent contractor documents. And if you are and have determined that an independent contractor is appropriate, what a document contracting that relationship should include and things to keep at top of mind when papering that relationship. So with that outline, let's get started. Why the classification matters. So a lot of people will come to me and they'll say, I have this contract for an independent contractor, or yes, they're an independent contractor, here is their contract, thinking that just having a contract that says independent contractor in and of itself is sufficient. None of the standards that we are going to look at today, under state law, under federal law, under the IRS rules, under the Fair Labor Standards Act rules, under Title VII, under the Americans with Disabilities Act, none of those rely upon or indicate that a contract in and of itself is sufficient to establish an independent contractor relationship as opposed to an employee relationship, right? You're also going to be looking at a multitude of risks that we're going to talk about, whether it's a wage and hour lawsuit from the worker, him or herself, or whether it's an administrative audit that's going to find that there were errors in your classification. So understanding that a contract is not what is going to dictate how we move forward. Generally, however, we know that an independent contractor is a worker who is going to offer their services to the public for a fee. Additionally, an independent contractor in most situations is not going to be economically dependent on any one single company. And this is very specific, they are not an employee. And one of the things that it is important for you to work on in using your vocabulary generally is making sure that when we talk about independent contractors, we don't refer to them as an employee. We don't use the same language such as they've resigned from their position, or we've separated employment, or we employ them in any sense. Those type of words conflate the two concepts and create a whole host of confusion whether to have an independent contractor or have an employee. So remembering that terminology is important. Additionally, when we're talking about independent contractors, these individuals, and we're going to talk about the different standards, but generally across all standards, they're going to be free to offer their services to the public, to perform work for other clients. Oftentimes, they're going to own their own business, and they provide services pursuant to their own terms or standards. An independent contractor typically is not going to receive company-sponsored benefits, such as vacation, health insurance, or retirement benefits. There might be statutory exceptions in which a state mandate would require that independent contractors receive a similar benefit to that which you are providing to employees. But generally, such as in Maine with the new earned paid leave statute, that applies to employees, not independent contractors. Additionally, independent contractors typically are not going to perform the same work as the company's employees. Independent contractors aren't someone who we bring in to test the waters and determine if later we want to turn them into an employee. Those individuals are called temporary employees. Temporary employees who we bring in, we see whether or not they're going to fit within the culture or the organization, and then we make them permanent employees, but not turning them from independent contractors into employees. And additionally, independent contractors are not going to have the indicia of an employee. And that would mean that they're not going to have company uniforms, the same company uniforms that your employees have. They won't have the same name badges or business cards. Those things aren't going to be provided to the independent contractor. You're going to have visual cues that would indicate that they are independent contractors and not employees. As an example, when I talk about independent contractors not performing the same work as the company's employees, an example is the best way often to describe this. Let's say hypothetically, a shoe store, and you want to contract with a graphic designer, and that would oftentimes, depending on the other factors, would be an appropriate independent contractor relationship. But if you were a graphic design company, contracting with as an independent contractor, a graphic designer likely would not be appropriate because all of your employees are also graphic designers. Instead, the graphic designer in that situation would most likely be an employee. Just so I just talked a lot about what an independent contractor has and doesn't have, but let's talk about what an employee has. So an employee, we know, is paid wages. receives company-sponsored benefits depending on if they're full-time, part-time, temporary, seasonal. They're employed for a continuous period of time and performs whatever tasks the company may be required. So those tasks may evolve and change over the course of a day, a week, a month, but the employer has the ability to change those tasks and duties. Generally, an employee, the employer is going to pay income, Social Security, and Medicare taxes through the amounts that the employer is obligated to withhold in those wages. The employee is going to be economically dependent on the employer for those wages. And additionally, most important things from a risk management and a legal perspective is employees are protected by applicable federal, state, and local employment laws, such as the Fair Labor Standards Act, Title VII, Americans with Disabilities Act, Family Medical Leave. All of those things are important to remember. Additionally, employees are going to be covered by your workers' compensation insurance policy, and independent contractors in most situations won't be covered by that. So let's jump to what the standard is, what the federal standard looks like. And this is one of those situations which, if you've attended other VERL seminars over the course of the years, you always say it's important to understand that federal law and state law matter. And in some situations, they're not parallel. And this is one of the situations where they're not parallel. So let's move forward to the federal standards slide. So in determining what the federal standard is, we identify what the risk, and this is where it becomes much more confusing. So we are going standards based off of different statutes or rules under the federal standard. So we're going to look at the Fair Labor Standards Act for one test. We're going to look at the control test for the IRS or tax purposes. And then for things such as Title VII, ERISA, the ADA, the FMLA, all of those kind of anti-discrimination statutes are going to have a complete separate standard. And that standard is going to be dependent upon where the employee lives. And this is just from a federal standard. We haven't even gotten into the fact that there's also going to be state standards that are involved. So let's talk about what the federal standard looks like under purely the Fair Labor Standards Act. That's called the Economic Realities Test, okay? So the Economic Realities Test takes into account 6 different points that are going to be analyzed by an agency or the court. The first one, and we've discussed this a little bit already, is the permanency of the relationship with the party. Is this independent contractor going to stay with you forever, or is it a term period of time? 6 months, a year, 2 years, 3 weeks, right? Is the time in which the services will be provided very clearly set forth? We look at the second factor, which is the degree of skill required for the rendering of the service. The higher the level of skill that is necessary to perform the task, the more likely it's going to be found to be that the individual as an independent contractor. And in part, that's because the more skill the individual has, the more time, energy, education, certification that they've put into garnering that skill or ability. Now, it doesn't have to be purely about being a professional or white collar. You could have individuals who have multiple certification and skill sets for something such as welding, and you need to bring a welding expert into your organization, but normally you wouldn't have the need for that welder. The third standard is the worker's investment in equipment or materials for the task. This is slightly different from that discussion about the certification or the education they've had. But what does the worker need to perform the task? If you are going to hand the worker everything he, she, or they need to perform the task, courts and administrative agencies are most likely going to say, nope, that is employee independent contractor. However, if your contracted worker arrives and they've got boxes of different things that they need, or files and flash drives with, I'm trying to think of how we now share technology and data. If they have a whole cloud platform that they are accessing documents or other things that your organization doesn't have, all of those created equipment or materials plays a role in the determination as to whether or not they're going to be an employee or an independent contractor. The fourth thing that we're looking for under the economic reality test of the FLSA is the worker's opportunity for profit or loss depending on the individual. This is a hard one that a lot of people oftentimes struggle with. If you're paying me by the hour, right, how can I have a loss? If it takes me 40 hours to complete the process, where's my loss? I just spent 40 hours. It took me 40 hours to do it. You pay for all 40 hours I worked. Potentially with an hourly arrangement, there could be loss because my time ends up being worth nothing because all of the materials that I had to use ended up costing more than what the hourly rate was. Or I had to hire other people. And even though you were giving me one chunk of money for an hourly rate, I then dispersed it to multiple individuals to assist in the project, and I paid them more than what you were paying me. In most cases, though, it's a hard argument to make that by paying on an hourly basis, there's that opportunity for loss. Instead, there would mostly be an opportunity for profit. If, however, you're paying on a per job basis, you then have significant discretion in whether or not there's a profit or loss. If you say that you're going to pay $800 for this project, and one person can get the job done in 5 hours, and for another person it takes 100 hours, their profit margin there is significantly different. So keep that in mind when we're talking about the FLSA and the economic reality test. The fifth standard is the degree of the individual's right to control the manner in which the work is performed. Do you give the independent contractor a list of 40 things saying you must do this, and then you must do this, and then you must do that? Or do you provide the worker with a task that must be completed? I need you to fix this machine. I need you to create an advertisement for this product that uses our company logo and that sets forth this information. Otherwise, have at it with these kind of more general parameters. But if you're saying, I want you to create a logo for me that is 2 ants sitting on a picnic blanket with a basket next to it, the more that you are putting parameters on it, the less control the individual has. Similarly, if you're saying the work has to be performed between 9 and 5 on these 3 days, and you have to be doing it at this location, and you have to be computer, all of those parameters, or the more parameters that you stick into it, the less likely that the individual has a right to control the manner in which the work is performed. And finally, with the FLSA economic realities test is whether the service that's being provided by the worker is an integral part of the individual or the company's business. And this goes back to that scenario I gave earlier, where you have a graphic designer who is creating a marketing campaign for a shoe company. When it's a shoe company hiring a graphic designer, that's outside of what the shoe company was designed to do. But if you have a graphic designer who's working at a graphic design agency, most likely that's going to be an employee, not an independent contractor, because it's an integral part of the employer's business. So that FLSA economics realities test, and you see there's a whole host of factors that are really important for us to look at that have multiple different degrees in which we're going to be analyzing. Let's next jump to the IRS control test. And this one, we're looking at 3 different factors: behavioral control, financial control, and type of relationship. And in many circumstances, there's some overlap with the FLSA standard, but not exactly. And that's why this becomes difficult, is because a court may find that someone is an independent contractor for purpose of labor act, and therefore the minimum wage and overtime requirements are not applicable. But for purposes of the IRS control test, they're an employee, and therefore using FICA, FUTA, Social Security, all those withholding should have been made, and you are on the hook for the payments. So from a behavior look at, right, to direct and control the worker. So the types of instructions that are given, the degree of instruction, the way work may be evaluated, and whether or not any training is provided. When we then jump to financial control, we're looking at whether the company has the right to control the economic aspects of the job. So how the individual is paid, if there's reimbursement for expenses, and then who's going to provide the tools and supplies. Does the worker have to provide those? More likely it's going to be an independent contractor. If it's company provided or sponsored, where we're reimbursing for those costs, more likely it's going to be an employee. And then finally, the type of relationship. So how is that relationship perceived by the person providing the services and the company? Do they have a written contract that's clear that they're an independent contractor? What type of benefits are provided? Are they the same as employees? And then is there a specific end date for the relationship? Is it set between the parties that it's going to be for a term, or is it indefinite in nature? So that's the FLSA IRS tests, which are two different but similarities to it. Then let's jump, however, to more general discrimination laws, as well as the Affordable Care Act and ERISA. And for those statutes, there's two standards. There's one that's known as the Darden test, and then there's one that's called a hybrid test. Now, the First Circuit, and for those who aren't aware, the First Circuit encompasses Maine, Massachusetts, Hampshire, and Puerto Rico, and Rhode Island. And then the Second Circuit is going to encompass Vermont, Connecticut, New York. So those, depending on where you have people, keep in mind, which that means that if you have in Maine and Massachusetts and also in Connecticut, using two different standards to determine whether or not there is an independent contractor for purposes of Title VII or the ADA or all these other statutes I listed. For the Darden test, we consider the skill that's required, the source of supplies and tools, the location of the work. Now that's a different one. Are they performing it at the company's operation? Are they performing it at home or at a coffee shop or some other location? You're looking at the duration of the relationship between the parties, which we had also looked at on the IRS test. We're looking at the company's right to assign additional projects to the worker. We're looking at the extent of the workers when. So this is similar to the behavioral control discussion that we had under the IRS control test, and also under the FLSA standard concerning the company's right to control the work that was being performed. The method of payment is going to be an element that's looked at. The workers running assistance or other individuals to assist in performing the task at hand. Also, the regular business of the company and whether the work that's being performed is part of that business. So going back to that IRS control task, the type of relationship, that's going to be our shoe company and our graphic designer. And then the company stays as in business. So is it a business or is it just somebody who's going out there and promoting their skill sets as an individual? Their role in the Darden test, which is used in the First Circuit. Now, of course, we can't make it easy. So in the Second Circuit, they use a test. And the hybrid test uses a combination of the Darden test, so the factors that I just listed under the Darden test, and then they also use the economic realities test, which is instituted under the Fair Labor labor standards. We're going to use part of the FLSA standard and then part of the Darden test in order to determine whether or not the worker is an independent contractor or an employee. Let's jump to the next slide concerning changes in administration and how that plays a role.
Thanks, Tawny. So before leaving office, the Trump administration proposed a new independent contractor rule. And really the purpose and intent behind this rule was to increase the opportunities for employers to be using independent contractors. So as you'll note here, the proposed rule was issued on September 22nd, 2020, and it was set to be effective in March of 2021. And to the point that Tawny was making about the economic realities test, under this proposal, the rule was reduced to 2 core factors. So focusing on the nature and the degree of the worker's control over the work and the worker's opportunity for profit or for loss. The other factors that were traditionally associated with the economics reality test were still important to the analysis, but they weren't given as much weight under this proposed rule. And we'll flip to the next slide to talk about the new administration and changes there. So taking a look at the Biden administration when they came into office in 2021, a regulatory freeze went into effect on January 20th. So effectively what this did was freeze the Trump rule. There were some other administrative announcements that were made, namely extending the effective date of the new rule, so they had more time to open discussion for public comment. And it's still in a frozen state. But what's really interesting about this is that the Biden administration actually has a completely different thought and approach to this whole issue. So throughout the campaign, the Biden administration has voiced support of an ABC test, as well as support of the Protecting the Right to Organize, or the PRO Act. And under the PRO Act, which isn't law yet, but it is being, it was passed in the House and is waiting in the Senate. These are the elements under the ABC test. And the purpose and intent behind this rule, or legislation, excuse me, would be to make it a more inclusive rule so that workers are more likely, I would say, to be classified as employees. So the elements are, you'll see on the screen, A, the worker is free from the control and direction of the hiring entity in connection with performance of the work, both under the contract for the performance of the work and in fact. B, the worker performs tasks that are outside the usual course of the hiring entity's business. And C, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So if we can flip to the next slide, please. What does this mean? You have a proposed rule that you're waiting to be effective, and then you have an active administration that has that rule frozen and has a completely different stance on what the rule should be. So it's pretty safe to say that the new administration is not going to enact the former administration's rule. Over the next couple of months, we should see some more information on what the rule will be. But I did want to focus a little bit more on the PRO Act and the implications that are likely to come out of that legislation if it is passed. So there's a whole bunch that's in the PRO Act that will implicate labor and employment, in addition to just simply the independent contractor and the employee standard. But something to be aware of is the effect of that the PRO Act would have on the NLRA, the National Labor Relations Act. So the PRO Act seeks to revise the NLRA to incorporate the ABC test that we discussed on the last slide. And the effect of that would be to reclassify millions of traditional independent contractors as employees. And where that becomes relevant for the NLRA is that the NLRA, the right to form a union, to collectively bargain, to engage in collective activity, is only applicable to employees. So should the act be passed and should, workers undergo that change of status, it would potentially open a bunch of industries that haven't had to deal with union activity to the potential of an organizing campaign, or at least discussion about that possibility. And that's important for folks that work in those industries that are traditionally based on independent contractors. And it could potentially impact your employee relations strategy if that's something that does come to be the new normal under this administration. So just want to point that out there.
And just to add to what Emily's saying so that people understand kind of the breadth of this, I mean, that would mean that individuals who are driving for Uber or Lyft or those entities that rely upon the gig workforce who work when they want without giving specific notice, without having specified times in which they need to provide services, those individuals could then potentially become unionized. So you could have an Uber or a Lyft union. And there's also the discussion of whether or not they could even consider or continue to be independent contractors, which is part of the discussion and argument that's happening on the West Coast right now, specifically in California, because California's state statute and rules are so much more stringent than what we see from a federal standard generally. So just to add on kind of the fact that for some industries, the PRO Act is going to affect all industries, but some to a much lesser degree than others.
Yeah, no, that's a great point, Tawny. It's certainly going to be interesting to see over the next couple of months what comes of it and what it looks like when enacted. And then the only other thing I would add regarding the federal standard moving forward is, continue to monitor the DOL for updates, the Department of Labor for updates on President Biden's proposed course of action, because I'm sure we are going to be seeing, announcements over the next coming weeks and months. It's definitely been a busy time in terms of agencies and federal law. So definitely keep an eye on that. And also, if I can make a plug for our HR blog, we'll be covering a lot of the new news that's coming through. So, and with that, I will hand it over to Tawny to go through the Maine and the Massachusetts standards.
Okay, so the good news is that the Maine standard is the same standard, whether it's wage and hour law, IRS determination, Title VII. We have one standard, which in most states is different. But while there's a lot of words on this slide, this is not the whole thing. So Anne, can you click on that independent contractor standard button so we can pull it up to everyone? Now, this is available online using the link that's provided in the chat window. So you can access this PDF and download it. And I highly recommend that you download it if you are in a position in which you're being tasked with determining whether or not someone is an employee or an independent contractor. And I like to call this my choose your own adventure document, right? Because depending on how you answer each of these questions determines whether or not you get to move forward to the next step. So it is a 6-step process, but even though I say it's 6 steps, we really need to say yes to at least 9 different topics, I guess is the best way to say it. So the first question we're going to ask is, does the individual have the essential right to control the means and progress of the work, except as to final result? Now, the good news is this first question is also a standard that we see under the FLSA, we see under the IRS test. So this one is not new or different from the standard that we have at a federal level, right? But if you answer no, don't waste your time asking the rest of the questions, because you have to be able to say yes to this question before you move on to the next question. It's not like the federal standard, where we get to take a whole bunch of the different questions and merge it together and then say, you know, can we answer yes to more than 50% of this, or that type of discussion. If you can't answer yes to this question, you have an employee, not an independent contractor. But if you, if the individual does in fact have the discretion and control, then they get to move to step 2. And in step 2, we ask, is the individual customarily in an independently established trade, occupation, business? This goes back to the that we had from the federal level as well. Do they have certification? Do they have training? Do they have a skill set that's specifically set forth for the work that they're going to be providing to you? And not just that, but have they kind of, I don't want to say marketed themselves to do that, but is that what they also do? I've had some people come to me and say, okay, we want to have a contract with this gentleman, and he's going to provide us with administrative oversight as to where we are in our business dynamic right now. And I say, okay, great. Is this something that he does? Well, he has a business. And I said, oh, okay, so he has a consulting business where he like comes in and helps other businesses who are at the same level. Well, not exactly. He owns a candy company. Okay, that's different. That is not someone then who's customarily engaged in helping with the transformation of a business at this growth level, right? That is a candy maker. And if you needed an independent contractor who is providing candy making skills or abilities, then that might fit the bill. But this would not be someone who customarily then is engaged in that transitioning type task. So your answer would be no, you'd stop and you'd make the individual an employee. But if yes, this is something they do regularly, then we get to move to step 3. And in step 3, we ask, does the individual have the opportunity, result of the services being performed for the entity? We talked about this one already. So if they do have the ability for profit or loss, we move to the next question, which is, does the individual hire and pay any assistance that the individual may have? And to the extent that the assistant employees, do they supervise the details of their work? So in all situations, you might not have this ability. It might be that you only need one person, that need anyone to assist them. But think of this more globally, right? Let's say you're hiring someone for a skill set that is very specific. If that individual hires a bookkeeper to assist them in the invoicing process, are you paying that bookkeeper or are they? I've seen contracts in which we end up, or the client ends up, not just paying for the skill that's being provided, but also then paying for a bookkeeper as well, who's creating the invoices. So we're paying somebody to bill us as well as to provide the service is being sought. That doesn't work. That's not going to work in an independent contractor situation. We would pay the one amount, let's say we pay $40 an hour, and then that individual is going to have to pay someone to do the bookkeeping for however many hours it takes in order to appropriately be considered an independent contractor. Next, does the individual make their services available to some client or customer community, even if their right to do so is voluntary, not exercised, or is temporarily restricted? So is this somebody who works with multiple organizations? It might not be that they work for multiple organizations at the same time, right? But they have to go or free to work with other organizations either before they contract with you, after they contract with you, and depending on what the need is, to be able to contract with other entities during the course of the relationship. It may be that you restrict it slightly. Maybe you don't want them working directly for another competitor during the course of the contract provision. And while the contract's being performed, that may be all right, but not likely all right to restrict their ability to work for someone else in the same industry following the termination of the contract. And then finally, step 6. And step 6 is where we have to look at multiple different standards. And for step 6, we have to make sure that the individual meets at least 3 elements of the following list of elements or factors. 1, the individual has a substantive investment in facilities, tools, instruments, materials, and knowledge used to complete the work. We know that that was required already under the FLSA and the IRS test at a federal level. So in order to meet both of them, meeting this would be important. The individual is not required to work exclusively for the entity, right? That one's a new one. That one's not set forth in any of the federal standard. 3, the individual is responsible for satisfactory completion of the work and may be held contractually responsible for failure to complete the work. So often when I'm looking at independent contractor standards or contracts, it feels very much like the beginning of a marriage. Everyone's so excited, everyone's happy, they're sure it's going to work out, and there's no discussion about what happens if it doesn't work out or how a party can terminate it. That becomes an important factor for the Maine standard, even though it's not something that's specifically set forth under the FLSA or the IRS test. Next factor, the parties have a contract that defines the relationship and gives contractual rights in the event that there is a termination of the contract prior to completion of the work. This is something Emily and I are going to talk about at the end of the presentation, but we really want something in writing. But of course, that's not surprising to any of you because we're lawyers and we always say, put something in writing. Payment to the individual is based on factors directly related to the work performed and not solely on the amount of time expended by the individual. This goes back to that standard that we discussed earlier regarding the ability or opportunity for profit or loss. And then the work is outside the usual course of business for which a service is performed. This goes back to the shoe company and the graphic designer. And then finally, and this one's different, but the individual has an IRS determination letter, which is called an SS8, that says that it's an independent contractor status, right? This is something that, depending on the length of the relationship, you might want to consider, or it might be something where you know you're going to have the need for independent contractors on a moving forward basis, providing this one task or job where you might want to get that determination prior to or in the early stages of this independent contractor relationship. So let's close out of this and let's jump and talk a little bit about what the risks or liabilities are under the Maine statute if you were to misclassify an individual as an independent contractor as opposed to employee. So the first thing to know is there's no safe harbor provision. There's no, oops, I didn't know, or I was unaware of this, I'll fix it immediately. So that is not going to provide you with protection in a misclassification situation. What you're going to be looking for from an administrative standpoint is a $100 to $500 fine for each violation. But then you're also going to have to pay unpaid wages to the individual. So let's say that you entered into a contract with someone and you said, I'll pay you $400 to perform this task. And it ends up taking the individual 80 hours to complete it. Okay, well, hold on. That means that for every hour that they worked, they only made $5 an hour. So you've just violated the state minimum wage statute. And not just that, but if it took them 80 hours in 1 week, you've also violated the minimum wage. So you're going to pay unpaid wages depending on how long it took them, what weeks they worked, all of those things. But then you violated the wage and hour statute. So now you're also paying liquidated damages in the amount of unpaid wages, which is going to be trebled. So you're going to have 3 times whatever the unpaid amount of wages was. You're then going to pay court costs and attorney's fees. So recall when we talk about attorney's fees, you're paying not just your own corporate counsel for the cost of defense, but you're also paying the independent contractors attorney fees for the misclassification for the amount that they should have been owed. And then also injunctive relief is available, which means that you would have to move forward and have them as employees, not as independent contractors. Now, what I hear most often from clients is this individual refuses to be an employee. They'll only work as an independent contractor. So I don't have any risk, right? Well, you don't have any risk until they sue you. And them saying, I only want to be an independent contractor, I won't contract you unless, I won't do the work unless I'm an independent contractor. Guess what? They're put all the risk on you because that is not a factor in any of the tests, right? So if you're trying to get work from someone and when you go through this standard, they don't meet the qualification for being an independent contractor, but they refuse to work in any other capacity, you have to discuss and talk with your operations team about whether you're willing to take on a risk that is very significant in terms of both the fines that the Department of Labor could issue, but more importantly, the costs associated with a wage and hour lawsuit. And for those of you who have attended any previous presentations, you know that wage and hour lawsuits are not something that you can insure against. Your EPLI insurance coverage is not going to protect you against these claims, which means it's all out of pocket and it's going to take a really big financial hit on your organization. So that's the Maine standard and the Maine remedies. We've got 14 minutes left. I am going to jump through the Massachusetts statute really fast because it's all very similar to a lot of the things we've already talked about. So in Massachusetts, unlike Maine, we have different standards again, depending on what the risk is. So we have the state wage and hour laws, we have unemployment insurance, we have workers' compensation, we have tax law, all of which have different standards. But it's important to note that the Commonwealth's standard from a wage and hour perspective is one of the strictest in the nation. So specifically, in order for an employer or a company to show that the worker is an independent contractor and not an employee, they must show that they're free from control and direction in the work is performed outside the usual course of the employer's business, and the worker is customarily engaged in an independently established business, occupation, trade, profession of the same nature as is involved in the services performed. So that's the business consultant who owns a candy store. That's not going to fly. It's going to have to be a consultant who owns a company. Now you're thinking to yourself, wait a second, Tawny, you just said it's one of the strictest in the nation, but all these things are things we've already talked about. The thing is, though, it's a review of all these factors, and the way in which Massachusetts courts have analyzed factors is very, very specific. So the proof that you need of all of these elements is much higher than it is in other jurisdictions. Something that you need to keep in mind. Under the unemployment insurance law, they use something that's called the ABC test. And the ABC test is exactly kind of what Emily set forth previously as to Biden's plans kind of moving forward. And Emily's going to also talk about it a little bit more when we're talking about the Connecticut Standard as well. Under the workers' compensation statute, so if an independent contractor were injured during the course of providing work, are they an employee for workers' compensation purposes and thus would be paid under your insurance? We are going to look at 12 factors: the extent of control, whether it's a distinct occupation or business, whether the work that's being performed is done under the direction and control of the organization itself. If the work is performed either, the skill that's required for that particular occupation, whether the individual provides their own tools and equipment, the length of time in which the services are being provided, whether it's a definite period of time or indefinite in nature, the method of something new that we haven't talked about or discussed previously. So how is payment being made? Is it with a check with taxes being taken out? Is it with FICA and FUTA being taken out? So that element. Is the work part of the regular business? Do the parties believe that they're creating master servant relationship, and not just what is written on the document, but what each party believes. Whether the individual providing services has a business or an entity that's been created, and then the tax treatment, how each of the entities applies that payment for the services from a tax perspective. And then under the tax law, we're going to look at the 20-factor test from us, which we already discussed. So the good news is Massachusetts has the same standard as is set forth in the federal IRS standard. So now let's jump to the Connecticut. Oh, sorry. So now let's talk about what the remedies are. Again, no safe harbor. So lack of knowledge is not going to protect you here. Individuals or workers are entitled to a private right of action, and they can recover unpaid wages, receive injunctive relief, and similar to Maine, triple the amount of damages for those unpaid wages, failure to pay minimum wage, failure to pay overtime. There's also, however, different criminal penalties that are available here. And that can be for a willful offense. If you know that you've improperly categorized them, a fine of up to $5,000 and or imprisonment, or if there's subsequent willful offenses of up to $50,000 or imprisonment for up to 2 years. A reminder as well as to one of the differences from a Massachusetts standard, CEOs and CFOs are personally liable for unpaid wages or wage and hour claims under Massachusetts law. So keep that in mind, that it's not just the organization that has it, but also personally the CFO or whoever is in charge of your finances, as well as leader, your CEO or president. Now let's jump to Connecticut.
So in Connecticut, we have two standards to take a look at. The first is the common law test, which is a right to control test. So similar to what we spoke about when we discussed the Maine standard. Here, the state will take a look at behavioral control, financial control, as well as the relationship between the parties. For unemployment, to Tawny's point, it is a different test. Here, the state will use a ABC test. The elements here are if the individual is free from control or direction in performing his services, B, performs his services outside the usual course of the employer's business or the employer's places of business, and C, is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as the service being provided. So fewer tests in Massachusetts, but good to kind of keep in mind the elements under each of these. If we can flip forward to the remedies slide. Great. So similarly to Maine and Massachusetts, there's no safe harbor available to employers. And there are also monetary remedies available. So either double the wages plus costs and attorney's fees, or wages plus costs and attorney's fees if the employer proves it had a good faith belief for the underpayment. There are also criminal penalties available for willful violations. And finally, something different that I wanted to point out in Connecticut, employees can also file with the Connecticut Department of Labor, who can assess penalties of $300 for each wage and hour violation. So while that might not look as significant as some of the other remedies that are available, it is something that is available to employees who can recover under these statutes. So it's important to keep in mind. So next, we wanted to leave you with some next steps as well as some terms if you're in the process of putting together an independent contractor contract. So first, something to keep in mind is to define the relationship as that of an independent contractor. Now, I know on the first slide we said, that's not the determining factor. And I think after going through the presentation, you all are quite familiar with that now, given all of the different tests that are out there. But this is still good to include just to make sure it's clear to the worker what their status is or what the intent is behind the agreement. So would still very much recommend including that. We'd also recommend a no assignment clause, which what this means is that the person you're contracting with is the person that's going to be performing the work. They can't delegate that to another party to do whatever the service is that you are contracting for. We'd also recommend that the independent contractor be required to have insurance, workers' compensation insurance, and other forms of insurance that are relevant for the industry. An indemnification clause would also be good to include for the company's protection. And finally, also including termination provisions around the agreement if possible to do so. So if it's an ongoing arrangement, perhaps providing a process for a day's notice requirement to terminate the agreement, or if it's something that's more project-based, you know when the arrangement is going to come to an end, include the end date there in that contract. And just something to be cognizant of, some non-poaching language could violate state laws in Maine, not so much in Massachusetts and Connecticut right now, but that's always constantly evolving. So definitely, keep an eye on that too if you're putting something in the contract that the independent contractor can't contact your employees for employment opportunities.
Something to actually, and can you go back just side? So something to add to what Emily just mentioned, specifically, you see that no assignment clause, and then you're thinking, but Tawny, didn't you say that one of the elements is whether or not they can hire other individuals to assist them in the project? So the difference between a no assignment clause and the ability for them to hire and pay their own workers is generally who's going to be responsible. So if I contract with Bob to provide the services, Bob could then contract with John and Sally to assist him in providing it. But what we don't want is for him to assign it to the organization Z to then complete it, and for him no longer to be involved in the project, right? So that's what we mean when we talk about the no assignment. And then from an indemnification provision standard, this is so important. I have litigated cases in which the organization unfortunately has paid, hundreds of thousands of dollars for the defense of a claim that is because they contracted with a subcontractor, and the subcontractor then entered into independent contractor agreements for individuals, and they should have been employees. So while your analysis, while you making sure that you've appropriately gone through all the standards to make sure that the service you're seeking is appropriate for an independent contractor, you also have to be mindful that the people you're contracting with, how are they treating their workers? If you don't have an indemnification provision included in the contract, you're going to be on the hook for their misclassification as well. So that's a really, really important thing to keep at top of mind when you're creating these contracts. And now, sorry, Ann, let's go back to that slide. Action steps. So what should you be doing moving forward, or what do we hope that you've taken away from today? 1, review your existing worker classification and ensure that it complies with state and federal law. And we gave you a lot of standards here, understand that, but segment it down, look at each position or look at each state and who do you have in those states. Create a database where you're able to very easily kind of have all the standards you need looking at and analyze it. Just train managers and employees who work with independent contractors on worker classification issues to ensure that their practices reflect the independent contractor classifications. So if someone came in from outside, are the individuals who are independent contractors treated exactly the same as those who are employees? Or when you go through your file system, it's going to be clear who's an independent contractor and who's not. On their name badge, is there something identifying them as maybe not a member of your organization, but a member of an outside organization? Have you been clear in your contract that these individuals are aware of, or they're going to abide by your rules and the standards that you have in place? If it's in a healthcare, station, care guidance and requirements, appropriate, like your non-discrimination and anti-harassment provisions, they are agreeing to comply with all those standards that you already have in place. and then draft agreements that document that independent contractor distinction using many of the terms that we set forth in the previous slide to make sure that you're clear as to what the relationship is and that all the parties are on the same page as to what the relationship is moving forward. That might be the first time in the history of Veryl Dana's Labor and Employment Practice Group that we have finished with a whole minute to spare. I don't see any questions. I know we threw a lot of information at people. We all, as Emily mentioned, this is an evolving standard, especially at a federal level with the new administration. So please, if you don't already get updates regarding the Taking Care of HR Business blog, please register for that using the link on your slide. And otherwise, thank you for your attention. We really appreciate it and have a wonderful